You're listening to Members of the Jury, the show that takes you straight into the trenches of justice, where the passion, players, and consequences are real. Each episode, we examine current events happening in the system. From the battles in courtrooms to the streets demanding reform, we bring those stories here to you, the members of the jury, because we aren't afraid to take it to the box.
What's up, members of the jury, and happy Freedom Friday. Thank you so much for tuning in to another episode. On today's episode, we will be doing a trial breakdown. And as I said before, in the universe of criminal defense, this trial breakdown is what some will seem as the pinnacle of cases and trials because it has one of the most serious types of consequences that exist in the criminal justice field. Today, we're going to sit down with a private defense attorney who is going to break down his trial of his client who was charged with murder. And as we know, murder most often comes with a potential consequence of 25 to life, and even in certain states, the possibility of the death penalty. So regardless of the facts, just the consequences alone put a pit in every lawyer's stomach, and to navigate through those types of cases are stressful, meticulous, and require a lot of collaboration and experience. And so fortunately with us, we are going to sit down with an incredibly experienced attorney, one who has seen cases from both sides of the aisle, and he is going to educate us as to how he was able to accomplish such a fantastic accomplishment. And so joining us today is Mark McKinney. Mark, please introduce yourself to the members of the jury.
Yeah, sure. Mark McKinney. I practice in Muncie, Indiana, home of Ball State University. I've been practicing law since 1991. Did about 15 years in our local county prosecutor's office, trying everything from traffic offenses all the way up to death penalty cases. After 15 years, moved back into private practice and have been doing that for about 13 years now, 12 and a half. So lots of experience, probably tried over 150 cases total over the years, and to jury trial, all felony cases. I still do public defender work. I have done public defender work for the last 12 years, and I enjoy it. Here in Delaware County where I practice, it's a contract basis, so it's sort of a part-time gig. You get paid a flat fee, and you do a certain number of cases every year. So that's my background.
I love talking with more experienced attorneys and still seeing how kind of giddy they are to talk about what they're doing, and it just gives me such hope and aspiration as a younger attorney to know that even down the road, there's still a way to have love and passion and excitement for the type of work that we do, and hoping and aspiring for the better outcome of a criminal justice system in whole. Not to mention, I love the fact that you're currently in the Hoosier State. That's where I'm originally from, and so I love always being able to connect back to my roots. Like most of my guests nowadays, I was able to connect with Mark online. And so if you would love to follow us, so we're available on all social media platforms at Members of the Jury. We love to connect with different guests. Please let me know if you would like to be a guest on the show, or if you have any ideas for episodes, and we'd love to follow up and connect with you. So Mark, get us into this case. I was able to see some of the little bit of the preliminary paperwork, but I really wanted to save myself in speaking to you to kind of learn directly from the source. Why don't you just take us to the initiation of the case? Let us know what the charging document looked like, all of the charges your client were facing as you ultimately decided to take this case to the box.
It started out, the event was early morning hours in the fall of 2019 outside of a local bar. My client was a designated driver for a young friend of his who had just turned 21. And he got off work, met his young friend and a cousin, actually, who had been out celebrating already. Met them at a bar. My client basically was a designated driver. So he was chauffeuring the other two around. They made it to a couple of other bars before ending up back where they started. At closing time, about 3 o'clock in the morning, the young man who had been celebrating was basically passed out unconscious, asleep, however you want to describe it. But he was done. So my client and his cousin basically picked up their friend and walked him out to the car. The entire incident outside in the parking lot was actually caught on security video. It was kind of a grainy video, so you didn't get a lot of detail, but you could kind of get the flavor for what was going on. As my client helped his friend into the front seat of his car, his cousin had already gotten into the back seat. It was a two-door sedan. My client walks around to the driver's side, starts to get in. There was an individual in the parking lot who had come over acting as though he wanted to assist. It seems from the video, at least, very congenial. At one point, this unknown individual pats my client on the back as they sort of unload the young man into the front seat. When my client gets around to the passenger side, for some unknown reason, this individual basically grabs hold of the frame of the door of the car and the car hood itself and kicks the young man who's passed out in the front seat right in the face. After that kick, he tries to load up and kick again, kind of loses his balance, and then just starts throwing haymakers on this poor kid who's passed out in the front seat. My client jumps out of the car, runs around. At that point, this individual who's attacked the front seat passenger sucker punches my guy in the face, kind of staggers him, and the melee is on. Now everybody who's left in the parking lot sort of gathers around, and my client gets knocked to the ground. He is encircled by a number of individuals. He's kicked, he's punched, ends up with a broken nose, black eyes, concussion. And the bouncer comes out of the bar, kind of gets everybody separated. There's jawing going back and forth. There's talking, some pushing, some shoving, some punches are attempted to be thrown. And my client and the young man who had, after being kicked and punched, actually had been able to get out of the car and engage at least somewhat in the festivities in the parking lot. They get back in the car. They start to pull out. My client realizes his cousin is not in the car, so he pulls up by the front door to let his cousin in. At that point, one of the individuals who was involved in the melee approaches the driver's door. He leans in, tells my client, "It's not over, I'm going to kill you." My client stomps on the gas and turns the wheel to try and get away. When he does so, his attention obviously is focused on the window here. He runs into an innocent bystander who is in the parking lot. That guy flips up over the hood, hits the front windshield, tumbles back down, and runs off. When the car lurches forward, the individual who has just threatened Aaron at the window falls down. He is over twice the legal limit, alcohol. We don't know if he just fell because he was drunk. He pulled off balance because he was reaching in the car when it lurched forward. We don't know. But Aaron now sees this guy flipping in the air, kind of has the oh shit reaction, puts the car in reverse and backs up to get away, to get out of there. And when he does so, runs over the individual who had come to his window and threatened him. Ultimately resulted in that individual's death. Aaron then takes off out of the parking lot. He's chased by another vehicle that fires shots at their car as they're leaving the scene, ultimately flattening one of their tires. He gets to a friend's house, drops the young man off who had been celebrating his birthday. And the next thing he knows, it's 6 o'clock in the morning, and he's gone unconscious as a result of his injuries. Kind of wakes up behind the wheel of his car and has no idea what has happened. So they preliminarily charged him with 2 counts of aggravated battery, which in Indiana is a level 3 felony, kind of middle of the road. I think 2 to 12 is the range of sentencing on the level 3, if I remember correctly. One count of leaving the scene resulting in death, and one count of reckless homicide. So that's the original charges that he is faced with. And then let's see, about 3.5 months later, the state decides to up the charges. They charge him with murder. In Indiana, 45 to 65 is the range of penalty on murder. An aggravated battery, leaving the scene of an accident, times 2. So we've now got the murder, level 3 aggravated battery, and 2 level 4s leaving the scene of an accident. So that kind of gets us to the initial proceedings. Originally, on the original charges, he had bonded out, so I'd remained out on bond for 3.5 months. When the state upped the charges, they issued a new arrest warrant, took him back in. We had a pretty good battle over bail. In Indiana, murder is one of those cases where you're not automatically entitled to bail. But if you can show that the state's case is particularly weak, you are then, after an evidentiary hearing, basically a mini trial, you're entitled to have bail. So we did that. The judge actually allowed Aaron to post bail. And so he thankfully remained out on bond until we tried the case almost 3 years later.
Yeah, and that was something I had a question about too when I had seen some of the initial pleadings of the paperwork. And so, yeah, and you also answered one of my other questions, was if anything had happened kind of in the interim between the initial charges and the amended complaint. And it sounds like maybe it was just their interpretation of their evidence, because you didn't already go to prelim or anything, right?
Yeah, we don't have a preliminary hearing in Indiana. So
wow.
It's,
okay.
The prosecutor files what we call a probable cause affidavit. And that's just a sworn affidavit laying out basically their best case scenario. In this particular case, they didn't reveal to the court that this was, the end result of a melee in a parking lot. They didn't reveal to the court that my client had been attacked, had been stomped, had been threatened. None of that was in the probable cause affidavit when they decided to up the charges. So when that came out at the bail hearing, I think it had a pretty good impact on what the judge's ultimate decision was.
And I think that highlights such a good purpose, quite frankly, of why we have the criminal justice system that we have, because you're entirely right. When I first read some of the initial paperwork, it's like very one-sided. It's obviously from the police officer's point of view and their most powerful witnesses, and then you hear it's on video. And I'm thinking to myself, like, wow, if this were the initial paperwork that I got on the case, like, I would not be too overjoyed. But then in hearing, all of the events that you say how they transpired, I could totally see now how, even despite in face of those objective facts and witnesses, how there's still another side to the story. And so I think that this already is starting off to be just a beautiful, beautiful example of why our right to go to jury trial is so important, and why we have public defenders and private defense attorneys as part of that system are such a valuable component to that. So we just heard basically that now they have upped the charges to some of the most serious level felonies possible in Indiana. Based off of that representation, I can't imagine that there was too much of negotiation as far as, realistic negotiations. And so the case moves on to trial. Take us to leading up to the trial.
Yeah, there very little. You're right. Very little negotiation whatsoever. I mean, those negotiation sessions really amounted to me telling the prosecutors, look, you've overcharged us. Just look at the security video. And while my client may be guilty of leaving the scene of an accident that resulted in death, he had a good reason to do that. He had been threatened. There were multiple individuals that were involved in the melee that, it's 3:00 in the morning. He has no idea who it is that kicked him, stomped him, threatened him. He has no idea, just trying to get the hell out. This clearly was not any kind of a premeditated or knowingly or intentionally didn't knowingly or intentionally kill anyone. This literally was an accident, a tragedy for sure, but just an accident. And the prosecutor's office just would have nothing to do with it. They took the stance that, well, we're going to let the jury tell us what they think it is. So we just geared up for trial. We took our time. We talked to our witnesses. There were a number of eyewitnesses. Of course, in the bar parking lot at 3 o'clock in the morning, everybody's story is going to be a little bit different. It was a real good example of why eyewitness testimony is not necessarily the best evidence for anybody. Everybody's story was different. Everybody's vantage point was different. Everybody heard things a little bit differently. So there were a lot of questions.
Well, and I can only imagine the type of reliability of your witnesses that you're getting from, more or less college students at 3 a.m, intoxicated in a dark parking lot, with individuals that they know. There's going to be so many different variables that partake in those individual stories, and so I think that's an excellent part, and why it sounds like a good investigation strategy to try to get as many stories as possible and from different vantage points.
Yeah, no, ultimately, at least in my mind, one of the bigger factors here was the individual who started the whole thing, right? The guy that comes up to the door and kicks the young man in the face. Ultimately, we were able to identify who that was. The police, I believe, knew, but hadn't done anything until we brought his identity to their attention. And then they end up charging him with a misdemeanor battery, actually 2 counts of misdemeanor battery, which subsequently get dismissed with no explanation. The guy never even hired a lawyer, just misdemeanor charges of 2 counts of battery that end up getting dismissed with no explanation whatsoever. And then at trial, they didn't even subpoena him to testify.
Well, that's why they dismissed the case, because that plays into your argument. So
yeah,
so many interesting facts going into this trial. Then obviously, we've talked about the type of magnitude that it has. In hearing that rendition of your story, it has to be one where I think you're really aligned with your client, and could see how he definitely got into that position and how that could amount to, basically acquittal of these charges. But despite all that, what did you feel like your biggest hurdle or obstacle was going to be going into the trial? Because as we know, once the trial starts happening, our hurdle becomes something way different than what we anticipated. So we'll get to that.
Sure. Yeah. I mean, the biggest hurdle is the bottom line. Somebody got killed.
Yeah.
And it wasn't a particularly gruesome crime scene. I mean, I've seen way worse, yet the average citizen who sits on a jury has certainly never seen an individual who's been run over by a car.
Right.
And we had the innocent bystander who he suffered he had to have a knee operated on. I mean, thankfully, that really was the extent of it. He had some bumps and bruises and ended up with like a torn meniscus or something. So what looked really bad in the video, he actually didn't suffer too bad of an injury. And so that I really was most afraid of the emotions of the jury and them not following the law. In Indiana, we have a pretty strong self-defense statute. We also have available to us an accident defense. And I felt very strongly that both of these applied for my client. He's exercising self-defense and trying to flee the scene, and he accidentally runs over the guy who's laying on the pavement. There's no way he could have seen. The car didn't have a backup camera. It sits very low to the ground. The side windows are pretty narrow. So and I actually got one of the police officers to admit that, yeah, there's no way if somebody's on the pavement anywhere near this car, there's no way he could have seen it. So that's sort of the scenario heading in. I felt like in all likelihood, my client was going to get convicted of the leaving the scene of an accident. Because in Indiana, you have an obligation when there has been an accident to stop and call the police and report it. And if you can't do so immediately because it's unsafe, then you're to do that as soon as practicable once you are safe. And my client very clearly never called 911. He dropped his friend off, and then because of the concussion situation, passed out basically at the wheel of his car and didn't wake up for hours later. So I felt very strongly about the murder, that really wasn't going to be a likelihood of the conviction, but I did feel like he was probably going to get convicted of the other. I just wanted to make sure that the jury didn't allow their emotions to overcome the common sense and the applicable law. And then frankly, one of the biggest developments pre-trial, we started the trial on a Monday. Friday afternoon, right before the court closed for business, the prosecution dismissed the 2 leaving the scene charges. No explanation, no reason for doing so, just filed a motion to dismiss. So now all of a sudden, I don't even have to worry about the crime that I think he might actually have committed. All I've got to focus on is the homicide, the murder, and the aggravated battery.
Yeah, I have an interesting question about that. Then when I'll circle back to closing, because I thought that the route that I thought that they were going to go were to kind of connect the two. Before you guys get into your opening statements, was there really any eliminate evidentiary battles that you had to put a lot of emphasis or focus on, or was it really just the kind of the factual dispute in this case?
Yeah, the state filed a large number of motions in limine, most of which we didn't even really fight about, honestly. That the facts, the video sort of spoke for itself, and the argument was interpreting that video. The state's argument was my guy had been beat up. He was pissed off because he'd been beat up, and he intentionally ran over the decedent and intentionally hit the guy who was the innocent bystander, even though he had nothing to do with anything.
I think that's actually a great segue, to really kind of expand on that for the state's opening statement. Like you were saying how initially in their probable cause pleadings, they really didn't emphasize the whole fight. Did they kind of stick with that strategy in their opening statement?
Yeah, very much so. I mean, their argument to the jury was the fight was over. As soon as the bouncer came out, broke everybody up, my client and his friend were able to get into the car, that at that point, the fight's done. There's no more imminent threat, which is the requirement in Indiana to use deadly force in self-defense. You have to have an imminent threat of serious bodily harm or death. That imminent threat had ended, and he should have just driven off rather than tried to pick up the cousin and then ultimately ended up driving into this crowd. So they're basically alleging that he was somehow the aggressor, the threat was over, and he was not entitled to exercise self-defense.
And do you feel like that was their focus because they were trying to establish that, premeditation intent for their murder charges?
Yes, absolutely.
So then when it was your opportunity to provide your opening statement, was that something that you really specifically attacked and really laid out of where the case was going to go, or try to just play back and really make the prosecution do their burden?
I very rarely will take the latter approach. I like to put my cards on the table. I like to tell the jury what I think the evidence is going to show them. If there are some weak points to my argument, I like to lay that on the table too. I've always believed that in order to be an effective advocate, first you have to believe in your case. If you're just full of bullshit, the jury is going to see that. But if you believe in your case, then you tell the jury, here's what I believe the facts are. Right. And, maybe we have a problem here, or maybe we have a problem here. However, overall, this isn't a murder case. Here's what it is. And I had a pretty good picture of my client with his face. I mean, blood all over his face and in his eyes, and his eyes are already turning black. And so I had a nice piece of physical evidence to show the jury just how badly he'd been beat up. So I felt pretty confident about that.
And that picture was something that you displayed during your opening?
I did.
Okay, and how did you feel? Did the prosecution lay out any visuals in theirs?
No, and I thought that maybe they would use the video, the security video during the opening, but they didn't. I mean, they had some PowerPoint slides about the law, but for the most part, it was sort of your standard. Here's what we think the case is about, and just went from there.
And so, and I'm wondering, like, especially since you had that prior prosecutorial experience of prosecuting a murder case, do you feel that's became very valuable to you in your practice now, as you are now on the other side?
Yeah, absolutely. I mean, I think having experience on both sides of the courtroom is extremely beneficial. The prosecutors that I see that are most effective are those who have had some private practice experience ahead of time, so have represented defense attorneys or defendants, and vice versa. I think the most effective defense attorneys are those who have had some prosecutorial experience as well. You know how prosecutors think. You know how prosecutors approach and prepare a case. You know how they've been trained. The officers. Those things you just can't underestimate how valuable that experience has been.
And I can see how that plays a vital role, especially with, like, I'm seeing how you're connecting really where they're trying to maneuver their evidence to especially get that overcharge of the murder with the required intent thing. So that's super helpful little nugget that I appreciate learning from you. Let's go into the prosecution's case in chief. I imagine that they're, especially in a murder, they're calling a lot of science and forensic evidence that really isn't being disputed here, what it sounds like. So, but it sounds like the biggest contention is really the intent, at least from the defense's point of view. So why don't you break us down where the prosecution really spent a lot of their time as it relates to that in their case in chief? Was it with some of the bystanders? Did they try to highlight the video? Was it some of the police work?
Yeah, so as far as the science goes, obviously they had the forensic pathologist come in and testify about cause and manner of death, and they put lots of gruesome pictures up on the big screen for the jury to see. They had an accident reconstructionist that came in and spent a whole afternoon talking about wheelbase of the vehicle and the tire tracks, and it was they made an error with this particular witness because I don't know if he spent a lot of time examining the actual security video, but the testimony that he provided about where the decedent was at the time he got ran over and how he was run over actually didn't match up to the security video. So, it made it easy in closing argument for me to just say, look, you don't even give that guy's testimony any credibility. There were some tire tracks in a field next to where my client passed out behind the wheel of his vehicle. And they tried to argue that he was driving through this bean field, in order to get rid of any blood or human tissue evidence that may have been on the undercarriage of the car, right? And testified about these tire tracks and the pattern and what his conclusion, his expert opinion was with regard to what was going on in that field. And I kind of said, all right, where's the pictures? Well, you can't take pictures of tracks through a bean field. Really? Because I'm pretty sure most law enforcement agencies anymore have a drone that you can send up and take an overhead picture. And he kind of went, yeah, we didn't do that. It was, like I said, it was easy in closing to just discount his testimony completely. So then we move into sort of the eyewitnesses, right? We have two bartenders that came running out. One of the people in the parking lot when the fight broke out came running into the bar, saying, hey, call the police, there's a fight going on, the bouncer's coming out. So you got two bartenders. You've got the innocent bystander that flipped through the air that testified. And that really, they called my client's cousin who he was, pulling up to help out, and then they called the young man who had got beat up, and that really was the extent of the testimony. And the bartenders were inconsistent in their stories. Of course, the cousin and the young man in the front seat of the car that got attacked were certainly testifying in support of my client and the fear that they were all in, and the concern that they had for their own lives. And then I felt like that really it kind of bolstered my defense throughout. In the end, the fact that they didn't call the guy who attacked the young man. There was another female who appeared from the security video to have been with the attacker. They didn't call her, even though they were able to ultimately identify her. They didn't call either one of those as witnesses. They didn't call the bouncer. So I called the bouncer in my case in chief. And he was also very supportive or corroborative of the story that I was weaving for the jury. He talked about the threat that occurred at the window. He saw the guy at the driver's side window that he basically, because he was on the other side of the car, he said he just disappeared when the car lurched forward. So and he very clearly was an unbiased witness with no connection to anyone, hadn't been drinking. I mean, he was maybe one of our better witnesses.
So it sounds like their strategy was really to call a lot of the aftermath players to really paint the picture as if the first incident wasn't really that bad. Things had died down. And then your client went on this vehicular rampage, just barreling down anybody in sight.
Yeah, that's a great way to put it.
Okay. So then, I mean, what was during your cross-examinations? Well, let me ask you this first. Despite them doing that strategy, I imagine they had were there any points that you felt that you really needed to address or kind of rebut despite that type of imagery that they were trying to create through their witnesses, like on your cross-examination?
I think as far as the eyewitnesses go, all I really did was point out the inconsistencies, really lock them in to the differences in their testimony, the differences of there are some things that one of the bartenders said that she heard or that she saw that the other bartender, who's standing literally right next to her as they watched this whole thing unfold, didn't see or hear. So I really tried to focus my cross on emphasizing where their stories differed.
Were you able to elicit the main fact that there was essentially this imminent threat at your client's window through any of the state's witnesses, or was that something that ultimately had to come out through your witnesses in your case in chief?
Yeah, so one of the bartenders, I did get her to admit that she heard someone say, "I'm going to kill you." She couldn't say where it came from. She was confused on which direction it might have come from. But to get her to admit that was a pretty big moment in the trial, I felt.
Well, and I would have to agree because just again, my readings of the initial pleadings, it was like some of the very initial interviews or police work were her almost reciting that, again, that the presumption that the police were trying to create was that she heard your client say, "I'm going to kill you," and then subsequently hit the guy. So if you were able to basically reframe that type of testimony without, it's being consistent with what she said, but just with a reframing, right? The defense's point of view from the police's point of view, I would agree that had to be a huge moment. So that's awesome.
And then I put my client on the stand.
Yeah, well, I was going to assume that, so in Indiana, do you have an opportunity to make a motion for dismissal after the prosecution rests their case?
Yeah, we call it a directed verdict.
Yep, okay, just make sure it's the same verbiage as the same here. And so, we obviously make those in certain cases, and it sounds like at this point, the prosecution had kind of did that to themselves with regard to some of the charges, right? At my understanding, right? That's what you said?
Yep.
And so then at the time that they rest their case, what were essentially the final charges that you were addressing with your case in chief and then ultimately at closing?
Yeah, so we were left with just murder and the aggravated battery. So killing killing the guy who fell down, and then the aggravated battery on the guy that flipped through the air.
Okay, got it. And so, yeah, we've heard. So you called. You said the bouncer, and I'm assuming that you spent most of the time with just your client.
Yeah. He took several hours of the last day.
Was that something that your client wanted to do?
Yes.
Okay, from the beginning.
Yeah. Oh, yeah. From the very beginning. Obviously, you can't make your client testify. You can't keep him from testifying if he wants to, but over the years, I've seen that it is very, very hard to make a self-defense argument unless the jury hears from the defendant themselves. Unless that individual can explain to a jury why I felt that I had to defend myself, I think it's very difficult. It's possible, but I think it's very difficult. The jury's always going to want to hear, obviously, from the defendant. But in a self-defense case, particularly, unless you just got a real problem defendant, I think you almost have to put them on. And my client was a great witness. He's well spoken. He was very emotional at all the right points. He controlled himself very well under pretty intense cross-examination from the prosecutors. Even when the prosecutors got heated, he managed himself very well.
I was going to ask about that. What was the prosecution's tactic with your client for their cross-examination to really try to elicit out of your client that he intended to do this?
Yeah, I mean, the prosecution spent a lot of time yelling in this trial, yelling at even at some of their witnesses, certainly at my client, their cross-examination, they did everything they could to try and shake him off of his version of the events, trying to make him look like he's just lying. He's just trying to save his own ass. This wasn't at all how it went down. He was pissed. He was angry. He's the one that said, "I'm going to kill you." And they just couldn't shake my client. He did great.
That's fantastic. Let me ask you this then, because it obviously was something that seemed to stand out to you with regards to the prosecution's demeanor. Do you think that was something that played any kind of either small or big role with regards to the jury and their kind of interpretation of everything? Because, that they're obviously hearing all the evidence, but then they're also seeing, the attorneys perform and hearing how they say. Do you think that their demeanor was also potentially picked up on?
Yes, absolutely. We got, we don't, in Indiana, we don't necessarily have an opportunity to talk to the jury after the verdict. They are instructed that once the verdict is read, their job is over. They no longer have to talk to anybody about the case. They can if they want to. And so we followed up with a couple of the jurors, and they certainly indicated that they didn't appreciate sort of the loud and aggressive style of the prosecutors, that they felt like they were trying to compensate for a weak case by being loud, basically.
We normally hear that as that's our job as defense attorneys.
Yeah, right. Yeah.
Nice to when the shoe's on the other foot.
And that's something as a trial attorney you have to pick up on. If you see that the jury is not reacting well, and so I went the other way, and I can be pretty loud and an asshole in court and very combative. And I went completely the other way and tried to just be as calm and, mellow as I could possibly bring myself to, just to sort of offset, the demeanor that they were showing.
Yeah, that's one of the skill sets that I'm still working on, trying to catch
it's hard.
More bees with honey than vinegar, because I'm full of a lot of piss and vinegar right now in my early days. So
And that won't go away. You'll learn to control it a little bit better, but it won't go away.
Yeah, I think that's good. That's in the spirit of what we do. Okay, so
Yeah.
so we're at closing. You feel like you just got done doing your case in chief. Was there anything that the prosecution really deviated from or focused on? Anything different now that the evidence has come out than they did in their opening statement?
Yeah, really. So in Indiana, the prosecution goes first in closing, then the defense gets up, and then the prosecution has the opportunity for the final word we call rebuttal.
I think that's the case I thought that was the case in every state. I was in law school. Just a little quick side note. I was in law school doing a mock trial competition, and it came time for the closing, and I was the plaintiff in this civil case, so I was getting ready to go first, but I was going against a team from Philadelphia, where I guess in Philadelphia the defense goes and then the prosecution goes. And so we had this argument about who was going to go first, because where we were from, it was different, but we were doing these national rules. And so that was my first experience realizing where it wasn't universally prosecution, defense, and then an opportunity for rebuttal. So that's interesting. I'm glad to learn that Indiana is also one of the states that falls into that. But so far, Philadelphia is the only state that I know of that does it any differently. So, but yeah, continue.
Yeah. So, I mean, as a defense attorney, rebuttal is just like the worst possible 10, 15, 20 minutes of the entire trial, right? Because you're just getting beat up and you have no opportunity to respond whatsoever. But in the prosecutor's first, in their closing argument, they played the video a couple of times and had picked up on something in the video, or at least they argued they picked something up in the video that I hadn't seen. And it was literally a glint off of one of the hubcaps, the wheel covers, that they were trying to argue proved my client turned the wheel into the decedent. And when they got done, when that closing was finished, I had a real pit in my stomach. For the first time in the trial, I thought, "Oh shit! I didn't see that. Nobody who watched that video ever saw that." And I sort of had a moment of panic. Took a minute to sort of gather myself before I got up. But it was a moment of feeling pretty bad.
Yeah, I could imagine that. Especially because I'm assuming the video is in evidence, and so even though it wasn't an aspect of the video that was maybe testified to, you can't even make the objection like facts not in evidence, since the video is in evidence, right. And that's just their argument as to what's happening on the video. So that is actually pretty crafty.
Yeah, it was good. It was good, and it caught me off guard for a moment, and I really had to sort of rearrange a part of my close to address that. And we had broken the video down into moments in time and had numbered each of them, and asked the jury to kind of count in their own heads as they went almost frame by frame through that video. And I think that was a pretty effective way to do it, because after all the closing, pretty quickly into deliberation, they asked to have access to the video again, so they could watch it and they could control how they moved through that video.
So one of the things I wanted to ask you about with regards to the prosecution's closing, as it related to what we were talking about earlier with the dismissed counts. In California, one of the things that I think prosecutors really like to rely on when they can in their closing arguments is when individuals, flee from scenes, because oftentimes they connect that to what they have a jury instructions on the consciousness of guilt. Is that something that played a role? And that's why I was confused that they would dismiss that charge, because I was thinking that they would argue, oh, he fled the scene because he had this consciousness of guilt.
Right, absolutely. And in Indiana, they've outlawed that particular instruction.
Oh, good for the Indiana.
Yeah, right. So you can't get that. You can still make the argument,
okay,
that fleeing from the scene may be considered consciousness of guilt, but you don't get the instruction anymore.
That's huge. Okay.
Yeah, it really was. It was huge. And they still argued that, of course. You fled the scene, you hid the car behind a fence row,
Right.
you drove through the bean field to try and wipe the blood off because you knew you were guilty. They absolutely did that. But at the same time, we have video of this SUV chasing my client out of the parking lot and off down the street a short ways. And both my client and the front seat passenger testified about the gunshots. That's pretty strong evidence, I thought, for justifying why you would continue to drive and then perhaps try to hide, at least for the time being, because you don't know if those people are still chasing you. You don't know when they stopped or where they stopped or if they followed you to the house. You have no idea.
Yeah, especially when you're dealing with a road rage type of scenario at that point, once it escalated from a bar parking lot brawl. So I think that sounds like a lot of good defense rebuttal points. What did you feel was one of your most successful points in your closing argument? And specifically, how did you recover from that hubcap argument that the prosecution made?
Basically, I argued the video spoke for itself, that what the prosecutors were claiming was shown in that security video didn't exist, and play it back and forth as many times as you like. You are going to see that at the moment in time where decedent leans into the car, and my client testified that, he leaned in, said, "I'm going to kill you," and grabbed for the steering wheel. And that's what caused the tires to turn. It wasn't any conscious effort on my client's part. And that it was consistent with, somebody from the outside leaning in and grabbing the steering wheel, which would pull to the left. If he's falling, again, that's going to pull the wheels to the left. So the what you saw on the video and the testimony of my client was consistent with, they were consistent with each other and consistent with the physical evidence. In other words, that's when the car lurched forward, that's why it turned the way it did. That's when he came in contact with innocent bystander, and just a complete accident.
It's kind of nice when you had the video to do a lot of the speaking and arguing for you.
And I don't know that we'd have been in anywhere near as strong a position without the video. The video of him surrounded by a circle of individuals who were punching and kicking him. I played that 3 or 4 times.
Yeah, I mean, that sounds like almost a scene out of a movie,
Yeah.
where, they portray people being attacked by, when you drive into the wrong neighborhood kind of thing. So you submit the case to the jury. How long do they deliberate for?
They were out 3.5 hours, I think. So not terribly long. I always feel if it's 20 minutes, that's a guilty verdict. And 3 to 4 hours probably favors the defense, and any longer it's a toss-up. So when they came back at 3.5 hours, I felt halfway decent about that walking into the courtroom.
And what were their verdicts as to the 2 remaining charges?
Yeah, not guilty on both.
Hey, Freedom Friday, let's go!
Right? Yeah,
that's fantastic.
Fantastic. Like I said, I've been a trial lawyer for 32 years. I've never cried after a verdict. But when I walked out of the courtroom and my wife and my daughter were waiting on me, I lost it. I mean, my client and his family had kind of become family to me.
For sure.
Over the course of 3 years, walking through this battle with them. And it was such a huge relief to see the justice system work. Justice was served. This was not a murder. It was not an aggravated battery. He didn't do it on purpose. It was an accident.
That is a fantastic, fantastic result. And with your client being out of custody, it just makes it even sweeter that you get to do that Hollywood type scene where you win the case and get to walk out of the courtroom with your client, because when your client's in custody, even when you win the case, you don't get to do that. So I had that visual.
Afterwards.
I have that visual of you with just congratulations. That's huge.
Yeah. He told me later, he's like, "Man, I wanted to kiss you so bad."
Wow, what an amazing trial breakdown, Mark. I really appreciate you spending that time and giving all of that education and importance into why we have the systems and resources that we do as it relates to the criminal justice system, and to having defense attorneys like you and myself in it, and to fight back against the narrative of, I understand that, like you said at the same time, like this justice and this victory for your client is, in my opinion, mutually exclusive from the tragedy and the horrible event of the life lost, regardless of their involvement in the brawl or not, and to the injury of the individual, right? You can have both things be true at the same time, and one shouldn't necessarily be directly related to the other, for good or bad. And so I think that does, this trial breakdown has done an amazing job of highlighting that.
It really was. I mean, I talked to the jury a lot in jury selection about just because a tragedy occurred doesn't mean a crime happened.
You explained to us how you have, over 20 years of lawyering, over 150 jury trials. I think you are a very appropriate guest to ask our signature question on the podcast. And that is, what is the significance of taking matters to the box?
The significance is that when it works, it renders justice, right? The outcome of this process was justice. And if it was left just to a prosecutor, would we have had a just result in this case? Absolutely not. I mean, they never were willing to entertain the fact that they had made an error in overcharging this case. It never were they, seemingly at least, in their conversations with me. I don't know what happened behind closed doors, but in their conversations with me, they were never willing to truly entertain the fact that they'd made a mistake here. And without the opportunity to present the entire case and to show a jury, 12 people picked from the community, both sides of the story, you never end up with a just result.
I love that. And I love that justice was done in this case. And again, I wanted to thank you for your time, your knowledge, and your experience. I know I learned a lot. I'm hopeful that my members of the jury audience has learned a lot. And we wish you the best of luck in any future endeavors that you have when taking matters to the box.
Yeah, same to you. Keep up the good fight.
Well, members of the jury, that's our show, and I rest my case. Be sure to come back next episode as we take another matter to the box. If you're a fan of the show, go ahead and subscribe. You can also find us on social media at Members of the Jury. If you want to be a guest or have any feedback, be sure to email us at lhursty@membersofthejurypod.com. Information in this podcast is provided as general reference work as a public service. The audience is advised to check for changes to current laws and to consult with a qualified attorney on any legal issue. The use of this material does not create an attorney-client privilege in any fashion with the podcast, the host, or the guest. This information is for educational purposes only, and no one affiliated with the podcast may be held liable for any decision made based on this information.